There we go. And so both of them will be placed up on the website as soon as we can edit them for anyone who isn't able to attend one or the other, or of course, for posterity in case you have questions. So this is the first of two trainings, as I said, and as those of you know who are here, our grantees, we're working on this form for quite some time. Riley will be touching upon the process that got us to this form, and we're really looking not only to train you on how to use the form, but we're also hoping to get your questions because that will help us refine the reporting form and make sure that we're as clear as we can possibly be so we have uniform reporting from everyone. So to start off, I'm going to introduce the ILS staff who are here on the WebEx, and then I'm going to turn things over to Riley so we can get started. Most of the names that I will call you'll be familiar with. We just want to make sure we can jump right in because we've got a lot to cover and we want to make sure we give you that 10-minute break in this hour-and-a-half session. So I'm going to start with Lucy McCarthy, who is the Director of Quality Enhancement for Parent Representation here at ILS. Kira Scatino, who is the Assistant Counsel for Parent Representation. Dai Nguyen, who is the Program Associate on Parent Representation. We also have Ian Harrington, who is the Attorney in Charge in the Western New York Regional Support Center. Jimmy Farrell is the Family Court Counsel, also out at the Western New York Regional Support Center. Riley Weinstein, as I mentioned, is the Family Court Research Associate here at ILS. Bethany Simpson is also helping us out today. She is the Data Outreach Officer here at ILS, and Bethany will be monitoring the chat box. So feel free to put your questions there in the chat box, and then we will direct them on to Riley. Or if it's something that is more of a legal issue and not a data reporting issue per se, that's why we have Lucy and Kira and Jimmy on to help us out with those. And as I said, I am Melissa Mackey. So with that, I will turn it over to you, Riley. Thank you.
Thank you, Melissa. Can everyone hear me?
Yes.
Okay, great. So nice to see you all here today. I'm very excited for our first ever PRR-195 training. I'm going to go ahead and share my screen. Okay, lovely. Thank you. Okay, so thank you for that introduction, Melissa. And today, this part one of the training is going to focus a bit on the. If everyone could please mute themselves, that would be great. I'm hearing some background noise. Okay, thank you. So for part one of the training, we will focus on the report background and dive into data reporting on investigation representation as well as caseload. Okay, so we'll get started with some background right now. So the PRR-195 is based on the ILS request for proposals, or RFPs, for parent representation, the ILS standards for parent representation, and the ILS caseload standards for parents' attorneys. And this form is to be completed by provider office. Additionally, we know that this report asks for a great deal of information, and we understand that as implementation and data collection capacity are still kind of underway and unfolding, we know that you might not be able to initially answer every single question on this report. We did build some flexibility into the form, so we have some open-ended response sections and an unable to report option in many of our questions. And of course, to clarify, the PRR-195 is for providers of mandated representation receiving the ILS grant funding via the model offices 1, 2, and 3, or the Family Defense Quality Improvement and Caseload Reduction grants 1, 2, and 3. And as implementation is in its very early stages for Family Defense Grant 3, those providers won't be reporting yet at this upcoming August 30th deadline. But I am very happy to see some of you here today. Thank you for joining us. This report is also informed by the individual provider/county data collection meetings that we at ILS have had with grantees. Also, our Parent Representation Advisory Committee, PRAC, and specifically the Data Subcommittee were instrumental in helping us develop the definitions for reporting to ILS. So thank you all so much. And lastly, this form reflects the data collection guides. So for recipients of the first and second Family Defense Grant, you may recall that last summer you had received a data collection guide tailored to your office's unique role within the grant project, as laid out in your county's work plan. So this form should look similar to that. Okay, so as I mentioned, the PRR-195 mirrors the initiatives outlined in all of our family defense RFPs. The 4 initiatives are primarily timely access, caseload relief, interdisciplinary representation, and training. And we are, of course, aware that your office's grant project may not include all 4 of these initiatives. You will only need to report on those for which you are receiving the ILS funding. So today we will focus primarily on data related to timely access, and we will also get into a little bit of caseload relief and interdisciplinary representation. So we are asking you again for a lot of information, and it's natural that you might want to know why, right? So why do we need accurate data? Well, first, it is to track over time the implementation of quality improvement and caseload reduction initiatives and mandated parent representation. Secondly, it helps us all of us gain insight into funding and practice needs and areas for continued improvement. And ultimately, with quality data, we can highlight the value of state investment and mandated parent representation. So the reporting period. Please note that for the first PRR-195, due this coming August 30th, we are on a modified schedule as we are funneling multiple grant timelines and accounting for various implementation delays. And so this first report will be cumulative from the beginning of implementation through June 30th, 2024. In an attempt to define the beginning of implementation, which is a near impossible task, we are using the ILS signature date on your grant contract. So you should have received an email from either myself or Dai Nguyen on June 27th containing the contract date for your county. We do know that this is not a perfect system, so if you didn't receive the email, please let us know, but also if you received not reflect what you see as the start of your implementation, or you have any questions about it, please just reach out and we can figure something out. The reporting deadline. So for this first report only, it is August 30th, 2024. And then beginning in 2025, we will move into a regular semi-annual reporting schedule with fixed reporting periods and deadlines. So here is a little visual for what that will look like. The PRR-195 will be due twice a year, once in August and once in February. The August report will be for the first 6 months of the year, so January 1st through June 30th. And then the February report will be cumulative for the entire calendar year, so January 1st through December 30th. So after this August 30th report, your next one will be due in February 1st, and it will be cumulative for the entire calendar year of 2024. Okay, so reference materials. These 2 documents here will be important for you to have on hand when you complete the form. The first document is the definitions for reporting parent representation caseloads to ILS. This document we had emailed you in the beginning of June, and the definitions are also embedded in the online survey for the report. So as you're filling it out, you can click on instructions and definitions and they will populate there as well. The second reference material here is, of course, your grant contract. So this is where we obtained that contract signature date that we had emailed you a couple weeks ago. And in that same email, we also sent you a copy of your budget and your work plan from your contract. And the budget and work plan will help you determine sections of the PRR-195 that are relevant to your office. Okay, so let's get a little bit more into the report. Most grantees are incorporating what ILS has termed investigation representation, or IR for short, which is the representation provided during the CPS investigation prior to court intervention, prior to a petition being filed. And essentially, IR is the mechanism for timely access to counsel. So in attempting to quantify this timely access, we will be collecting data on things such as the number of IRs, the outcomes of the CPS investigation, information regarding family separation and reunification, ancillary legal issues that parents might be facing, and lastly, how specialized services such as social workers and parent advocates are incorporated into the representation. These data over time will help ILS understand and track implementation progress and needs. So the report questions themselves. So the first 3 questions are very straightforward. This is the provider demographic information. They ask you to indicate which grant you've received and grants, and whether you are an institutional provider or an assigned counsel program. And lastly, which case management system you use. Next, we move into the IR section. So you will be asked a screener question to see if your office provides IR under your ILS grant. This is most likely laid out in your work plan. So if you don't provide IR, you will automatically skip the entire section when you select no, and you'll proceed to question 18 on the report. If you do provide IR, you will proceed to the next set of IR-related questions, beginning with number 5. Questions 5 through 7 ask you to report the total number of IRs opened, closed, and pending during the reporting period. And so each time I refer to the reporting period in this training, I am referring to that like contract signature date through June 30th of 2024. So these IR caseload numbers will provide us with insight into the volume and the timeline of IRs. And to ensure that you're classifying opened versus closed IRs accurately and consistently, you can click again on the instructions and definitions in the report. And you can also view the definitions document. Question number 8. So if you are unable to report the number of IRs open, closed, and pending, please provide any relevant data that you currently collect in the comment section below. So this is sort of a catch-all for the IR section. If you have any missing or incomplete data, just please provide an explanation here and share any relevant information that you have on IR caseloads. Okay, so question number 9 is about the CPS investigation outcomes. So in how many IRs closed in the reporting period were the following true? On the far left, we have a list of the CPS investigation outcomes. So for IRs closed, please indicate the amount of IRs that resulted in a filing, and you specify whether the petition was an abuse petition or a neglect petition that was filed. And then you can also specify the amount of IRs that did not result in a filing, specify whether the allegations were indicated or whether they were unfounded. These categories are mutually exclusive. So if you add up the numbers in the column under number of IRs, it should be equal to the total number of IRs closed during the reporting period. So that's a good way to verify the data. Okay, so question 10, in how many IRs that resulted in the filing of an Article 10 petition did the IR attorney continue to represent the client in the Article 10 proceedings, i.e. vertical representation? So a little bit of background on this question. Many providers indicated in their grant proposals or even in their work plans that they had an interest in implementing continuity and representation from investigation through the Article 10 representation. So that's why this question is here. So please provide the total in that box. And if you are unable to report, you can select that. Number 11. So this is about IR clients and dependents, often children. So of the IRs closed during the reporting period, please report the total number of clients represented and children who were subjects of the CPS investigation. So this is a little bit different in terms of the unit of analysis. Here we are asking about the people rather than the IRs. So in other words, who was impacted by this representation? And just a note here that the total number of clients represented does not necessarily equal the number of IRs that were closed, because technically one client could have multiple IRs during the reporting period. Okay, this is our question about family separation and reunification for IRs. So for IRs that have been closed during the reporting period, please report the total number of removals that occurred during the CPS investigation pursuant to Family Court Act 1021, 1022, or 1024. So if you are able to specify the mechanism of removal, that is really helpful, because we can understand, trends around that the mechanism that CPS is using. And then the second column here asks about family reunification. So of the children that were removed, how many were returned to their parents? Right, 13. So for IRs closed during the reporting period, please indicate how many of the other petition types listed below were pending for the same client at the same time that the IR was occurring. So for example, if 6 clients have pending custody and visitation petitions, you would put a 6 next to custody and visitation.
Riley?
Yes.
I have a question about the prior question. Are you able to?
Oh, yeah.
Is this an okay time to ask?
Yes, go ahead.
Okay, so this is not data that we would collect at the investigation representation case. This is data that would be collected in an Article 10 case. We wouldn't leave an IR case open beyond the investigation stage. You know what I mean? We would close out the case, and then some of this information might be information we don't even know. Some of it we might know, but in any case, we certainly wouldn't be tracking how many children were returned to their parents. Like, all of the data that you're looking for here would then go into an Article 10 case, not track forward from an investigation representation case. Does that make sense? Because those are cases that are resolved generally within 60 days. So when my grants department and I were going through this form, that was one of our questions. We're just gonna never be able to, and I don't know how, and maybe other people collect it differently or count cases differently, but for us, that's data that gets collected in the Article 10 data collection, and isn't something that we could,
I see.
I just didn't know if anyone else was struggling with that, or I wanted to clarify that and just share that. So
yeah, that's a good point. These questions are about the IRs closed, so it makes sense that you would collect that data after. You're right. You would get that information after the IR was closed, and I see what you mean. If it became petition, then the data you have would be tied to that petition rather than the IR.
Exactly.
Yeah. Do you have a way to connect the petition to the IR, like the previous
Not in the
representation?
way that will allow us to answer this question in the investigation representation.
Okay.
It would be very complicated. We can certainly answer it in an Article 10 case at the close of the case, right?
Uh-huh.
It's just, and we can tell you whether when the case came to us, whether it came to us at an investigation stage or a Article 10 stage, right? We can tell you that. But this we can't tie it back.
Okay.
Not without an immense amount of convoluting.
Yeah.
Like, it's not, you know what I mean? Like, I don't know that that would make sense. I think what you're looking for here, right, is more tied to the work in the Article 10 case.
I agree with that. I think that once we open a petition, that's when we get this information, but we're not necessarily involved with the CPS investigation stage.
Mm-hmm. Okay. Yeah. Okay. So that's all good feedback. I appreciate that. So again,
Oh, I'm sorry, Riley. I think, Sharon, was that you who made the comment about your not being involved in the investigation representation stage, and you'd get this information if the petition were filed?
Right. And we can look back into that, but I don't know that we'd have this information prior to getting a referral for representation.
So you're not currently doing investigation representation?
Not that I'm aware of. I'll check with our
Okay.
family court attorneys, but not that I'm aware of.
Okay.
I'm sorry, this is Jessica Anderson. I'm from Sharon's office, and I'm a managing attorney. We do not typically get assigned for investigation representation.
Okay.
I think we've
Oh,
had
I'm glad I got that right.
we've had maybe one in the last year. We typically get assigned once a petition is filed.
Okay. So then I'm wondering, so we discussed this for a very long time internally, and so I don't know, Lucy, I know Lucy and Kira and Jimmy, you're all on here. Is there anything you would like to add about the genesis of this question? It was my understanding as we were having the internal conversations that in some of these investigation representation cases, children will have been removed and that providers would know that. So is there anyone either internally or who's currently doing IR that they are or are not able to collect that information? I see your hand up, Joanne. I just want to give our internal team a chance to comment on this.
Unfortunately, so Erie County is doing some investigation representation. Unfortunately, their numbers have been very low due to limited buy-in from DSS. They're relying totally on community outreach. So unfortunately, I don't have a good answer to that question.
Okay.
I don't know if anyone else might.
Okay.
I guess I'm,
Lucy?
yeah, I'm confused by reading our own question. So that's, I think what we're trying to find here is whether or not CPS put the children in foster care, or is that what we're trying to capture? Because they would need to file a petition to do that. Or is this question meant to capture when they tell, a family member to file an Article 6 and take custody? What we know is shadow foster care.
right. I mean, I think this question was getting at removals that occur before a petition is filed.
So emergency ones, right?
Right.
It would
And
be
so-
filed subsequently, immediately, so you would
Exactly.
close it. Right.
That's where I understand
Right.
that, we're talking about these very distinctly, the IR and the petition representation,
Right.
but they aren't distinct things, but that is what the question is getting at. And so if your office doesn't provide IR, you wouldn't even also have to answer any of these questions. So that's the good news.
But sorry, this is just a question related to that. If we have, so how do we avoid duplicating our numbers in this? Because like, just for instance, we do the investigative representation. We have a child who is removed, a petition is filed, we're following it through, and then that child is returned. Are we reporting it here? Or I assume there's going to be a subsequent question about Article 10 representation and in court, and how many children were returned after that. So should we be reporting it here, or should we be reporting it there in the case where we're doing both?
Yeah,
Does that make sense?
fair question. Yeah.
Yeah, I think that does make sense. That is a good question. I think you would still report it in both places because the questions are not going to be the same, but also we're not looking for a total number of children that were removed in both instances, if that makes sense.
Oh, it does.
Okay, yeah, we're
Yeah,
just
if we
looking
could
at
put them in both places. Yep.
we're looking at the distribution of removals, and later on with the Article 10 representation, we ask a little bit more about the placements. So it won't be a problem to report twice.
Okay,
Yeah,
thanks.
that makes sense, Melissa.
Yes, it does. That's what I was going to say. We want to be able to report on the totality of investigation representation. And then when we report on the petitions, we'll be able to have that caveat as we report any of the data that some of these petitions may have begun as IR, but don't add, as Riley said, don't look to add them up and have it cumulative.
Yes. Okay. These are all great questions. Are there any more for this one?
Hi, Ariel from Monroe County. So the majority of our IRs that have been coming in, a small number of them result from like informal safety plans. So technically the children are removed, but they're not removed by court order. So where do you want those tracked?
That's the shadow foster care that
Right.
Yeah.
Maybe I think it could make sense to just put unknown. if you
Okay.
want, and then, yeah, should we do that for now?
I think so. I think what I'm hearing is that there wouldn't have been, right, the petition, as Lucy was saying, the petition wouldn't have been filed yet. It's shadow foster care. They're asking if someone else in the family can take it, can take the children while this matter is pending. And so I think it makes sense to say unable to report or unknown.
Mhm.
The number of children removed.
But I think it's important to note that our work, this is Kevin from Erie County, by the way. Who told you that? Our investigation work is, the goal is to prevent the Article 10 petition from being filed. So with our involvement and representation, if, even though I think that shadow foster care is a horrible thing because it's not voluntary, it's coercive. You know, and in many instances, if we avoided the Article 10 petition from being filed by working with the family and helping them, the parents agree to a safety plan, and it prevents the Article 10 from being filed, it was a successful representation in the pre-petition work. And I think it's fair to note that as no petition being filed and a success story. And I was taking an important call. I apologize. I only heard part of what Jimmy Farrell said. It's true that our numbers aren't huge, but I think that with the hard work that Holly, our lead social worker, and a couple social workers we've had at Erie County Assigned Counsel, with the outreach, we get a lot of calls in our office for the pre-petition work. They're not always on point. People hear about, you know, CPS investigation, your rights, do you need an attorney? So we get a lot of calls, and our current social worker, Mary, spends a lot of time fielding these and weeding them out until they get to me. But ultimately, everything that's a legitimate CPS investigation comes to my desk. And I've been doing this for about 1.5 years. And I don't have the numbers in front of me. I think we're at about maybe 70 cases that I've represented people on. Oftentimes it's very, very short. You know, it's talking to the CPS Office of Counsel and saying the family needs to do this, or just have the lady schedule an appointment with the doctor's office and we close the case. So, I mean, there's not a lot anybody is going to do on a spiral fracture for, you know, for an infant as far as preventing that Article 10 from being filed. But on the cases that we do get, there's some work that we're able to do to prevent the Article 10 from being filed. And out of the 60 or 70 that we've had, only one's been filed so far for what's, you know, from our involvement. So, and I know that downstate, I don't remember if it was Westchester County or where it was, they had similar numbers to that previously. Their program's been around a little longer than ours. I think they had 1 or 2 out of 200 in their reporting.
That's right. Similar results for sure.
And by the way, I apologize. I didn't mean to I think I phrased that badly, and I apologize to Kevin because I know he's doing great work and Holly's done great work.
I know where your office is, Jimmy. I'm coming to find you.
Yeah, no, but again, I think I phrased that badly. They're doing great work, and again, I need to talk to him about the data more. And then again, in my mind, 70 cases is small when well, I was a public defender for 12 years and had insane numbers. But again, I apologize. Again, I phrased that really badly. I don't want to come off the wrong way.
I understand what you're saying, Jimmy, and I think the more important part of your statement was that we are not getting cooperation from DSS, and it's making it so much harder for us to effectively represent our clients. And so, topic for another day, but I think we will see a huge difference in this field once we can get the Parental Bill of Rights passed.
All right. Yeah, absolutely. So are there any other questions here before I move on to the next slide?
Just to ask those of us who don't do the IRs, we just jumped to question 18.
Yes, yes. So when you answer no, we don't provide IR, you will automatically jump to section.
Thank you.
You're welcome.
Riley, there is a question in the chat. Can you see it, or would you like me to ask it out loud?
If you wouldn't mind reading it, I can't see it.
So there's
I
two
can
questions.
Sorry, I can also unmute and just ask my question. Sorry,
Oh,
I didn't want
yeah,
to
go right ahead.
derail us. I mean, I agree that I think it's a little bit hard to, sorry, this is Zainab from Neighborhood Defender Service of Harlem. But I agree that it's like hard. We don't really track like whether a removal is a 1021 or 1022 or 1024 removal when a case isn't filed. But the way that I'm reading this is that you would count it as a 1021 removal if there was consent and they followed the requirements of 1020, which was the 1022 would be a removal with a court order before a petition is filed, and 1024 is a so-called emergency removal where there's no court order. And so I don't get the isn't, sort of thinking through, well, is this a 1021 or a 1022 or a 1024? They don't talk about it that way. They just do what they feel like doing. But that is how I would understand how to break down the
I don't know that I caught all of that. I'm sorry. I did hear a little bit though. So
like.
Right, we're having an audio problem. Some of what you were saying was breaking up for us. But I think I think the gist of what you're saying, I'm sorry to jump in, Riley. The gist of what you were saying is that in the city, they're not making that distinction between one of these. And so then where would you know? And then there's the next question is what sources of information should we rely on to report this? The parents, a CPS investigator. I think what you're saying is, I think what both of these are saying is we won't know which of these it is at the time that it's happening or even perhaps after. And so I think in our internal conversations, we recognize that, and that's why the unknown category is there. And so if you're not able to, and you don't have a source for that information, and you're not able to get that information, that's where you could put that. But you know that children were removed, you could put it in unknown.
Yes.
Okay, got a thumbs up. I did see Joanne Sorokin, you had previously raised your hand and we went into a different area. I didn't know if you had any additional information or additional question.
I was just going to say we're kind of in the same boat there because sometimes we get the cases later in the game, so we weren't part of the case at that early point in time. And we're counting removals of children and returns of children, but we're not doing it at the IR stage. So we do want to report it, but we wouldn't be able to report it here. It would get reported at the Article 10 stage once the Article 10 case is closed. So so this will also, I don't know that this will help you as much as you hope, but I mean, we'll do our very best because we will be able to maybe I don't know. Like, I'm just not sure that this is,
Right.
as long as all of these questions are getting asked at the Article 10 stage, we'll be able to do more robust reporting.
Absolutely. And, you know, the challenge that we have in developing these is that we have a county-based system. I can personally say for me, stupidly went into this thinking that since these are all OCA courts, everything would be done the same way. And I was quickly proven wrong. And so as you see in our definitions, we're trying to find a way of collecting data that encompasses all of the different practices and tries to standardize it for reporting purposes. But we know throughout, and you'll see unable to report as an option in a number of them, that there could be reasons for any number of reasons, whether it's your data collection, how you're doing it now, as you said, Joanne, or simply because you aren't given that information, that you'll be unable to report. And so choosing unable to report is not a mark of shame in any way in our eyes. It just helps us to better understand how everything is functioning in your county. So you should not feel poorly if you're not able to do that and you're not able to get that information.
Could I also add, Melissa, just for everybody listening, that like all data reporting instruments, this one, we didn't etch this one in stone. Meaning if obviously something becomes, we learn that what we've asked is impossible, then that requirement would of course change. We would realize we're able to correct ourselves that way. This was a big task for us to undertake. No one's reported family court data to us before, and for our research unit, they were learning family court representation from the ground up. So I think that it's safe to say that we're willing to and happy to be flexible if it turns out what we're asking for is not something that's possible. Is that fair to say, Melissa?
Absolutely.
Yes, thank you, Lucy and Melissa. I completely agree. We really are all in this together. This is the first report. We'll see what you can do, and we'll do our best to get as complete data as possible, understanding that total completion might not be possible.
Riley, there is one last chat question before we move on.
Yes.
What sources of information should we rely on to report this information? Parents, CPS investigators, what sources?
I might turn that over to Lucy.
I would say, given that the difficulty, any resource that you can get your hands on, if you have the information, you can report it. Parents will probably not know. You might be able to find it in the court's records, or ACS might know. But if you can get it at all, I think that you will call that reliable. How's that?
Right. And again, if you are unable to report, you can select that as well. Okay, next question. So for IRs closed during the reporting period, please indicate how many of the other petition types listed below were pending for the same client at the same time that the IR was occurring. So for example, if 6 IR clients have pending custody and visitation petitions, a sixth should be recorded next to the custody and visitation here. So this is really getting at ancillary family court petitions that clients are involved in. Okay, so this next question is similar, but it is about the overlap between investigation representation and criminal legal system involvement for clients. So
Riley?
Yes.
We have another chat question, sorry.
Okay, yes.
Should we include criminal court matters as well?
Oh, so I guess whoever asked this question anticipated the next question. Yes, but in a separate question. So 13 is about ancillary family court cases and 14 is about criminal. I'll just reread the question. I'm sorry, I don't know where I was. So of the clients with IRs closed during the reporting period, how many clients were also charged with a criminal offense related or unrelated to the CPS investigation. So here we are assessing the totality of client involvement in the legal systems. Many providers have shared in their implementation memos that it was very useful to coordinate with their criminal defense counterparts, as clients are often entangled in both systems. I think I just saw a question pop up, but it disappeared.
Yes, it says must be pending during the IR period.
Yes. Can I provide any further clarification on that?
Sorry, that was me. I was just wondering because often they're former clients of ours on the criminal side. Is this if they're not currently involved with the criminal justice system while the CPS investigation is going on, you don't want to know about it? Is that essentially?
I think we're talking about open involvement, right? Current.
Right.
Okay.
Right. So during the period of your representation while they're under a CPS investigation, were they also involved in a criminal court case? And so we recognize that some of your clients will have previously been clients, but this will give us, no, it doesn't have to relate to the IR investigation. I jumped around there. This is our opportunity. When you're developing caseload standards, I'll take us back just a little bit. You can develop them either as new cases that are filed, or petitions that are opened. You can have caseload standards based on cases or petitions that are closed or have reached a final disposition, or you can have them as pending caseloads, the number of cases that are currently open at any given time. With both of our criminal court caseload standards and these parent representation standards, we chose having cases opened or new petitions filed, or open or investigation representation. But by asking these questions, both question 13 about other family court matters and question 14 about other criminal court matters, then we can see kind of what the totality of representation looks like. Because we really don't know how, like, the average number of petitions. This goes back to when we were developing our caseload standards. Some of our providers in New York City were able to tell us that their Article 10 cases would include on average, I think 1.5, right, an average of other petition types. This will give us some sense of like the totality of representation that your clients are requiring. And then I'll go back to, do the criminal charges have to relate to the IR concerns? No, we want to know if they're related or unrelated. Any kind of criminal court case, whether related to the CPS or ASC investigation, we want to know if that's happening. And then I also see Lauren saying the type of criminal case would be very difficult to report on, and we recognize that, and that's why we said unknown. And so if you know that your client has some other criminal court matter pending, but you don't have a way of coordinating, then you can report that we know that they have a criminal case, but it's unknown what type of criminal case. And then also you see there, it says, yes, but the specific charge is unknown, right? So you can say, I don't know if there are any other criminal court cases pending, or yes, I do know, but I don't know what the charge is. So yeah. Right. And we understand that, Joanne. I see that you won't be able to. And that really comes from, as Riley previously said, that there's coordination, we know, in the offices that do provide both criminal court representation and parent representation. And so that will be easier for them to report. But for those who aren't able to tell us the specific charge, it would be useful if you were asking the question and you were aware that there was another matter happening in criminal court. So Lucy, I see that you had your hand raised?
Oh, you got it.
Okay.
One last question in the chat. Can you define related? Would it be a charge directly leading to a removal, such as endangering the welfare of a child, or a concurrent charge, such as violating a protective order?
It can
be either. Oh, I'm sorry. Go ahead, Riley.
Oh, sorry. Yes, it can be either. and the question says related or unrelated. So it doesn't matter whether it is related or unrelated to the CPS investigation. Okay. Next question. Okay, so this is, so we have one more question. When, oh, it disappeared, sorry.
When counting criminal charges only in this county, or if we know has charges in other counties?
That is one that I hadn't conceived of, but yes, any other criminal charges.
Mhm. Okay, so for question 15, it asks to please report the number of IRs closed during the reporting period in which any of the following grant-funded services were utilized. So for example, on, let's say 20 IRs, you utilized the services of a social worker / case manager. So you can enter the number then 20 here and indicate whether these services were provided by an outside contractor or personnel. So also known as an in-house or salaried social worker / case manager. And so you would just go through and do this for every specialized service position. If you have a specialized service position that is not listed here, you can report it under other.
I've got one more question. If we don't have that information about criminal, can we just check unknown? Does that suffice?
Yes. Yes, or unable to report. If you can't report on that information. I think unknown could be, that unknown section could be used for if you know there is a criminal charge, but you just don't know the type.
Joanne Sorokin, you've got your hand up.
I'm sorry in advance. I ask a lot of questions. You should see me in medical appointments. Okay. So on cases, we sometimes have multiple assignments under 15. So we might have a social worker and an advocate, or we might have a social worker and a social work supervisor. So if everybody is involved, right? So we might have more assignments than we do cases. So you're just, that's fine, right? Okay.
Yes.
And if it's not using ILS funds, so let's say we have a paralegal on a case because I don't know why. At the IR stage, we probably wouldn't, but at the court-based stage, we might, but that's not funded with ILS funds. I'll ask that question when we get to it. Like on the off chance, if it's not ILS funds, right? It's only ILS funds, right?
That's correct.
Okay, great. Thank you.
You're welcome. Okay. No other questions about that, Bethany? Okay. Okay, so the next question is a narrative form of the question. So it asks you to please provide a summary of your office's use of grant-funded specialized service personnel in IRs. In your response, please describe how specialized service personnel are assigned and ways in which the utilization of specialized service personnel has positively impacted representation. So in other words, this question asks you to summarize how your office has utilized in-house or salaried specialized services. So again, those were the same specialized service professionals that were listed in the previous question, such as social workers, parent advocates, etc. Oh, yes, Ariel.
Hi, sorry. I probably should have asked this on the previous one. So for our office specifically, we have investigators on staff, but they're not paid by our ILS grant. So if we use them on IR cases or even Article 10 cases, do we report that we used our in-house investigators, or do we not report that to you guys at all since they aren't being paid through the grant?
So if they're not funded through the grant from ILS, then you would not report them here.
Okay. All right. Thank you.
You're welcome. Okay, so the question 16B is nearly identical to 16A. However, rather than asking about the specialized services personnel, so the in-house people, it asks about the contracted specialized services. So we separated these two questions out with the hope that we can understand any similarities and differences between how the personnel versus contracted specialized services are utilized and how that impacts representation. Do you have another question, Ariel? I can't tell if the hand is still up from the last one.
Nope, I forgot to take it down. Thanks.
Okay, no problem. Okay, this next question is about IR barriers. So just ask you to please provide a description of any barriers to providing investigation representation here. So as some of you have mentioned, maybe there was a struggle to negotiate with DSS, struggle to get referrals, any of that you can put in here. Okay, we are at our break time, but I can also take any questions that you may have right now before we go.
I have a question. Can you hear me?
Yes.
Okay. We use, for our general work, we use this PDCMS program. I'm sure everybody uses a similar program. Is there going to be a separate program available for this that would enable us to summarize statistics over the course of a year or 6 months? Are you aware of any program that would be available? Do you know what I'm talking about?
Yes, absolutely. So we have representatives from ILS who have been working with us, from NISDA who have been working with us on the development of the definitions, and also we've been consulting them on this form. So they are aware that this is the type of information we're going to be collecting. And additionally, as each of us was meeting and Riley was meeting with our grantees, we provided a 1-page or sometimes a 2-sided page of the different variables that, based on your RFP and your plan, you intended and we agreed that would be collected. And we recommended that those be shared with whomever, because we do have a number of different vendors with everyone here. So we did ask that that be shared, but we did in fact also share that with NISDA. So my assumption is that they will be working on that and getting a form that, getting a canned report, so to speak, that you'll be able to use to extract the information. But you can follow up with Darlene and her team over there at NISDA about that.
Yeah, just one quick question, and I know everyone has to go to the bathroom. So at the end, when we hit submit on this form, will the system kick back a copy of what we submitted to us? Because our county wants to get copies of what we're submitting, and that's going to be the easiest way.
Yes, yes, it should give you a copy automatically. We have had some issues in the past where it does not. If that's the case, we will send you a copy. You can just reach out to us.
Yes, it generates a PDF, and so we can send that back to you if it doesn't allow you to save it at the end.
Mm-hmm.
It's hinky sometimes.
Yeah. I think Beth McKinney, did you have a question?
I was just trying to answer Joel. I think he disappeared, but I have been in contact with PDCMS just to let him know. I have provided them with your beautiful package here. So I think they are kind of aware of what we're looking for. Whether they're working on it or what's going to become of it, I don't know. But I do try to keep them in the loop as much as possible.
Okay, all right, great, thank you. Okay, so if that's all, we can now take our 10-minute break and we can come back at 3:10. Okay, got it. All right, so the good news is we've gotten through the majority of the content for today. So we'll jump right back in here at Public Outreach Campaign Tasks and Initiatives. So this question 18 is a screener question. So it asks, do the grant contracts, or does the grant contract for your office include funding for public outreach campaigns and initiatives? Please see attachment B1 of your contract if you are unsure. So this attachment B1 is the budget that I had mentioned earlier, the one that we had sent you before your training. So this should be pretty straightforward. You should be able to see if there is a line item for public outreach campaign tasks. So if you do have a budget line for public outreach, you can just click yes, and you'll proceed to the next few questions. And if not, you'll click no, and you'll skip this subsection. This asks you to summarize your office's efforts to inform the community regarding the availability of public defense representation during a CPS investigation, so IR. Yes, Joanne.
Sorry. Okay. So we had a question about this when we were going through it, right, Joanne? Our question was, so we do outreach. It's not funded by this grant.
Mm-hmm.
So 18, we would say no, but then on 19, do you want us to talk about it? Because it's going to skip. So you don't want to hear about our outreach efforts unless it's funded. I guess the only thing that I could say is funded is like sometimes we use staff time to do community presentations.
You use what? I'm sorry, I didn't catch that.
Sometimes like one of our members of our team will do a community presentation.
Mm-hmm.
People who are funded, but it's not, we don't have specialized funding. It's that they're going to a community provider meeting and talking about the work.
Mm-hmm.
So how would you like us to handle that?
That is an interesting twist. So if I understand, it's not in your budget. You didn't have anything in your contract or your budget specifically for outreach. But as the model office, some of your team members who are funded by the model office grant are actually doing some forms of community outreach.
Yes, it's a part of our model. It's a part of what we wrote about in the grant. It's part of our model. We go to community network meetings. We, social work team, especially whenever they're doing outreach to various providers to talk about, like to find out if they could be a resource on a given case, they're also doing outreach themselves in that moment and talking about this, introducing ourselves, talking about what we do.
Right.
So
Right.
So I don't know how to answer even the 18 question because, sorry, don't mean to make it complicated.
So Riley, excuse me, if you would allow me, I think the easiest way to do that would be to say that no, it's not being specifically funded, and then it would skip the rest of the questions. And I say, even though they're funded by the grant, they weren't specifically hired to do campaign outreach, et cetera. And I think when we go through the remaining of the questions, it would be more difficult for you to answer them. For example, we're asking how many referrals did you get from that specific campaign that was funded? And so that would be difficult to answer and wouldn't exactly be clear because it's not based on the campaign. So these questions are specifically for providers who indicated campaign and outreach were part of their plan and it's included in their budget. Riley, is that the best summary?
Yes, yeah, that's perfect. Thank you. And I think there was also a question about which ones you would skip if you don't have this funding. You won't need to think about this. It'll automatically skip for you when you select no, but you will skip to question number 23. So you'll skip 19, 20, 21, and 22. Okay, so yes, if you are receiving funding, this is where you'll just summarize your office's efforts to inform the community of the availability of IR. You can include information here such as meetings, networking events with other community agencies, like mental health agency, for example, any distribution of information, pamphlets or flyers that you've done, coordination with criminal defense or other legal service providers, and so forth. These are just examples. Okay, so 20, please provide the total number of IRs received from each referral source. This was the question that Melissa had just referenced. So if you are able to report here and you can provide the numbers for each referral source, we have DSS, community organizations, other attorneys within or from outside of your program, and then self-referrals. So for example, via community outreach campaign, flyers, social media, maybe potential clients learned of your services this way. So we have this question because some providers indicated that they plan to or already had been collecting this information as it can be internally useful. So you can, offices can kind of identify what the best or most efficient way to get the word out might be. So if you can report numerically, that's great. And if not, you can simply select unable to report here. And then we have a text box in the next question where you can provide any narrative or anecdotal information about the referrals. So this could be, for example, trends you may have noticed. Maybe you notice a lot of referrals coming from, supportive housing or a certain healthcare facility. Or maybe a lot of clients say they heard about you on social media, for example. This is another catch-all, more open-ended option. Question 22 here is another screener question, and this asks whether your program created an on-call phone line or procedure to monitor the intake of IRs. Again, this is where it will be useful to refer to your budget and your work plan. So if you do have an on-call line, you will click yes and proceed to 22A, B, and C. Maybe six. All right. Okay, question, 24-hour line or regular business line? I think this, I'm not sure if I fully understand the question, but I think that this question in particular is asking about whether you have a line specifically dedicated and funded to monitor the intake of IRs. So it wouldn't be just like the regular phone line that you've been using in your office, if that makes sense.
Right. This is another one of those. Did you specifically state that this was one of the things that you were going to do? And I know there is at least one provider under one of the grants that said they were going to create an on-call phone line as a way to get the word out and to be available to do quote unquote intake in these IR cases. So if you weren't funded specifically to do it, then you don't have to answer the question. And then if you were funded to do it, whether you did a 24-hour line or it's a regular 9 to 5 or 8 to 4 or 8 to 6, and either one of those would count. But were you funded to do it? Yes or no?
Yes, exactly.
Good questions, Ariel. Thank you.
Mm-hmm. Okay, so if yes, you were funded to create this on-call line, we'll just have you answer these 3 follow-up questions. So first, how was the on-call initiative implemented? This is a pretty open-ended question, but you could talk about how you staffed the line, what you did to sort of roll it out, what the hours are for the on-call line, for example. 22B is how many calls were received during the reporting period. This is just a number. Hopefully that's pretty straightforward. And then lastly, please provide a summary of successes and challenges related to the on-call line. This can just be a brief summary of what you have experienced successes and challenges. Maybe callers have expressed positive or negative feedback about it. Maybe it's difficult to staff the line, to find people available to monitor the intakes, whatever information makes sense for you to provide here. Okay, so this next section is on office-wide attorney caseloads in family court. So although the ILS family defense grants focus on child welfare specifically. It's also important to collect data on the overall caseloads in family court, as it does impact the Article 10 work and capacity and resources. So when completing this section, it will be useful to reference the ILS caseload standards for parent attorneys. That is on our website right now. And then again, you can reference the definitions for reporting. This is the chart from the ILS caseload standards for parent attorneys. A mouthful. In the interest of time, I won't delve too much into the background of these standards. Melissa did speak a little bit earlier about them, but I just wanted to throw this chart here to show you briefly how petitions are weighted. So as you can see, each petition type is assigned a weight based on the minimum average number of hours it takes to complete representation for that petition type. So if we look at neglect, abuse, and TPR petitions, they are weighted the highest at a 9. And what that means is that they, on average, take 9 times as long to resolve compared to a paternity petition, which is weighted at 1. So to the extent that you can provide complete data in these categories, it will be very useful in helping us assess how these ILS caseload standards function in practice. And it can also help us understand and quantify the caseload needs that you are facing. So if you haven't had the chance yet, I would recommend reading through this full document on our website, and please feel free to follow up with me with any questions you have about it. Adoranki, did you have a question?
Yes, I do. Maximum proceedings per year, is that for all counties or for a specific county?
The maximum proceedings per year.
Yeah.
So that's the maximum for, it would be every county. That's what ideally, but that we're not looking to evaluate necessarily like your office's fidelity to that. This is more about assessing our caseload standards, understanding how they function in practice, and just seeing what caseloads are looking like.
Okay.
Does that make sense?
Yeah, got you.
Okay. Okay. So questions 23, 24, and 25 ask you to report the number of petitions opened, closed, and pending during the reporting period. If needed, you can select unable to report and provide any data that you currently collect relevant to caseloads and an explanation in question number 26. So this is what the chart will look like for those questions about petitions open, close, and pending. So in question 23, you'll provide the totals for petitions opened, and 24 totals for pending, and closed, sorry, and in 25, you'll provide the total for petitions pending. As you can see on the far right-hand side, there's the button for unable to report, which you can select if you aren't able to pull the numbers for a specific petition type. When responding to these caseload questions, it is important to refer to the definitions for when a petition is opened or closed. These are the definitions that are for ILS reporting purposes specifically, and they're there just so that we can ensure that there's consistency in how everyone is counting petitions. There was a question that came through the chat. Bethany, would you mind?
Yeah, so it says the maximum cases is per attorney. However, we are reporting for the entire office. Is that correct?
Yes, this is office-wide. We're not asking per individual attorney to report caseloads.
Right, it's an aggregate number. And for those who aren't doing IR and who are their grant is more focused on caseload relief. Having the office-wide caseloads reported continually over time, we can see if the addition of another attorney or et cetera impacts the office-wide caseloads over time.
Can I just ask, are, if you receive both forms of assistance, the reporting period for the IR and the Article 10 is going to be from the date the contract was signed until June 30th of this year. What is the time period for the overall caseload? Is it also specifically going back to the date that parent representation contract was signed? Or, I mean, should we be using the same timeline for all of the reporting?
Yes, yes, it's the same reporting period for all of the questions.
Okay, regardless of when we received funding for petitions other than the early defense.
Yes, yes.
Okay,
Mhm.
thanks.
You're welcome.
So it sounds like you don't just want the information that's funded by ILS, that you want, like, if there's, so for example, like, we could have an Article 10 case open funded by ILS, but also have other types of cases open that could be funded by ILS or could be funded under another grant. So you want everything, but
Yes.
only if the person has an ILS funded case as well.
No.
We do.
No, for this, I'm sorry to interrupt, Joanne, for this one, for the overall cases, that we want everything that you do. So IR is specifically grant funded, and in some of these, when we get into the next sections, we'll go back to that, but the office-wide caseloads is just that. Regardless of the funding source, we want to know what, again, the totality of representation looks like for your program. And we do that because, as Lucy said, on those of you who report on ILS 195 itself, we only get trial level and appellate level. This is our first opportunity to get information by these different petition types. So we want to have the totality of all the cases that your program has represented.
Okay, so I have a follow-up question then. So do you want the county information? Do you want the organization information? Because all this work that you're listing here, I do it in my office. We have 4 offices in our county. They all do it. We have 7 counties. They may do that. So like, where do we draw the line?
So I would draw the line at the office where the model office is at currently. Does that help?
It doesn't actually give you accurate information, because maybe I'll take this question offline.
Okay, yeah.
We'll talk
We'll
about it
figure that
separately.
out.
Okay, great. Thank you.
There are a couple of other questions in the chat. Bethany, would you like to take it from there?
Yes, there's 2 questions. I'll do one at a time. The first one is, this number includes total cases assigned for the year, even if closed, or is it total number of cases left open / pending in a given year?
So we asked the question, well, first to answer the question about the reporting period. So we're not asking about a given year, we're asking about the current reporting period, which is contract signature date through June 30th. So we're asking about that parameter. And then we ask for the numbers separately. So the number of petitions opened, and then the number of petitions closed, and then separately the number of petitions pending.
Right, so you're going to report for the number of petitions opened from contract sign date through June 30th, the number of petitions closed from contract sign date through June 30th, and then the number of petitions pending on June 30th.
Yes.
Is this not duplicative of questions 5 through 7?
It's duplicative only in that we're in the first section, if you do IR, investigation representation, we're asking about those cases. And now this is another section for anyone who's doing only caseload relief. They're not yet doing investigation representation, and then for everybody else. So this section is for everyone else because we want to know what all provider offices, what does it look like under these caseload, these petition types.
Okay, there was a second question. Are the caseload numbers impacted if one client has multiple custody petitions, since the attorney would be appearing in court on multiple petitions? To clarify, one court appearance would hear multiple petitions.
So if I understand correctly, I think what you're saying is that oftentimes when there are multiple petitions, they're kind of, for lack of a better term in my mind, bundled together. And so while you'll have a custody petition and you might have visitation and you also have an Article 10, you're going to go before a singular judge at one time and you're going to discuss each of these. If I'm getting that correctly, the reason we ask by specific petition type is because we know that is what happens. And so we know that an individual client may have multiple family court related matters being heard at the same time. So to get even though you might hear, and this is what I understood from talking with our team internally, you might be doing the same type of work perhaps as the attorney representing to satisfy everything that's happening in each of those petitions, but sometimes you're not. And so we really wanted to get a sense of how, like, for example, as I mentioned before, you may have one client, but that client has 3 different matters pending. And so we want to try to get to a place where we understand that on average, clients in family court have 2.5 petitions at one time. So the caseload numbers are implicated by that fact that one client could have multiple petitions at one time. And we are cognizant of the fact that it doesn't always mean that you're going to do 3 times the work, but we do want to know how many matters are being represented by the program for their clients. Does that help to say?
And just to clarify, you're talking about court-based representation. If we provided advice on a case, you don't want to know about it in this section.
Well, no, this is for petitions opened. So if your client has an Article 10 filed against them, then this is where we want to hear it. If the client is being investigated, but no petition has been found, then you report that in IR. If you're providing representation, I don't, advice, then I don't know what type of advice that would be outside of those 2, but we can add that to our offline conversation so I can better understand.
No worries. Thank you.
Okay.
Also, from a grants point of view, this is Joanne, the other Joanne. From a data point of view, it's easy for us to see at case closing if there was a petition for which we appeared. From a data side, it's very difficult for us to see when it's opened. I just wanted to throw that out there.
Oh. That part I'm not sure. So when you say when it's open, are you saying you're providing representation, a petition has been filed, but you won't know what type of petition?
No, I'm saying that the people that are generating the reports on the data side know by the close reason and the level of service at the case closing that, yes, we did appear in court for this custody case, or yes, we did appear in court for this, but we don't know when a case is opened what level of service will be provided. Because
I see what do you mean, yeah, like whether there'll be a social worker assigned, et cetera, et cetera?
No, whether there's like just looking at the case information that comes through the case management system, we don't know if there's a petition involved at case opening, but we know at case closing.
So sometimes people come to us with with the family offense matter, but they're not yet ready to file. So they talk to us about their case. and then at some point we file on their behalf, or they say to us, yeah, I've decided I don't want to file, right? Or I don't want to file right now. So when the case is open and pending, until the case is closed, grants can't measure what the level of service is.
I see. So I think if I understand, and we'll move on because we're actually a little past time and we have a couple more.
And
I think what you're saying is that until the petition is filed, you won't be able to identify what type it is in your case management system. And that's most readily apparent at the end of the case, as opposed to as you start providing that advice. So if I understand that correctly, then we'll clear that up offline too.
Thank you.
Sure. Sorry, Riley.
No, that's okay. So we have the definitions here for when a petition is opened and when it is closed and how to count that. I won't read through them just because we are over time. So I'll just go to the next question. So 24A asks, of the petitions closed during the reporting period, how many clients were represented? And we would like you to provide the numbers by petition type. So this is what the chart will look like. And this is where you will record the number of clients represented on each petition type. Just of note, these categories are not mutually exclusive because, as we were just discussing, multiple clients can have multiple petitions. So if you add up the numbers here, they will not equal the total amount of clients represented on petitions closed. So again, since this is only for petitions closed during the reporting period, so if you close neglect petitions for, let's say, 15 clients, then you would record that here next to neglect. On the other hand, while maybe your office has provided representation on TPRs for 2 clients during the reporting period, if you did not close those TPRs during the reporting period, you would not record the 2 clients here. Okay.
We have a quick chat question.
Oh, yes.
If they have multiple types of petitions, do we count them in all categories?
Yes, exactly. That's correct. So really the numbers here should add up to a much higher number than the number of individual clients that you had. Okay, number 25. So this asks for you to report the number of petitions pending on June 30th, 2024. So that includes petitions that were neither opened nor closed during the reporting period, but for which representation is still ongoing. Then question number 20.
I'm sorry, and I just want to point out, based on the discussion that we just had a minute ago, that we don't see that until it's closed on the data side, that the pending that would fall into the same problem for us.
Okay. Okay, that's good to know. We will figure it out. Okay, number 20. Oh, yes, Mr. DeBose.
It can be resolved in an email. I don't want to, we're already over time. I'll catch up with it later.
Okay. So number 26 is just the catch-all. So if you were unable to report the total numbers above by petition type, please provide any data that you currently collect and an explanation. So maybe you just can't separate out all of the petition numbers by petition type, but you can provide some cumulative total here that is appropriate. Okay, so this question will look different depending on whether you are an institutional provider or an assigned counsel program, and you would have selected that back in the beginning of the report. So if you are an institutional provider, you will be routed to number 27, and this asks for the total number of full-time equivalent attorneys who provide family court representation. And then additionally, of those attorneys, how many provide Article 10 representation? So if, for example, one attorney splits their time 50-50 in criminal court and in family court, that would count as a 0.5 FTE here. And then if you are an assigned counsel provider, you will be routed to question number 28. And that just asks for the total number of attorneys on the assigned counsel panel who provide representation in family court matters. Okay, so we've gotten through all of the questions for today. This is the end of our part 1 training, and we hope to see you at the part 2 training in 2 weeks on Thursday, July 25th. That one is at 1 p.m. to 2:30 p.m. And like this training, it will be via WebEx. And in part 2, we will dive a little deeper into Article 10 and TPR representation, some grant-funded positions, questions, and questions about training and CLEs. And lastly, we'll talk about how to submit your PRR-195 report. And just as a reminder, the reporting deadline for this report only is August 30th. And then in 2025, we will move into that regular semi-annual reporting, which will be February 1st and August 1st of each year. I know that we are out of time, but please feel free to follow up and reach out to us for any additional questions you have. I know there are already some that we will continue to discuss. So this is there's a family court data inbox. It's fcdata@ils.ny.gov, or you can email me directly. All right, thank you so much, everyone. I will see you in 2 weeks.
Thank you so much.